Hello and welcome to Courts Today by LiveLaw. Let us start with the top headlines. The Supreme Court has issued notice on senior advocate's plea to quash FIR alleging that he took 7 crore from a client to influence judges. In a matter concerning Sambhal Violence before the Allahabad High Court, it has allowed withdrawal of a PIL against police atrocities, noting that an inquiry panel has already been formed by the UP government. In a 1984 Anti-Sikh Riots matter, the Supreme Court has urged Punjab government to consider relief for 39 families who were unable to prove they are genuine riot victims. The Supreme Court has sought Union's view on Bihar Election Commission's plea against election of a Nepali citizen as Panchayat mukia. The Supreme Court has reserved its order on ex-West Bengal Minister Partha Chatterjee's bail plea in money laundering case. The Delhi High Court has clarified that collecting funds in illegal way to commit scheduled offence in future is not money laundering under PMLA. Saying that Urdu language is not widely known, the Rajasthan High Court has said that nikahnama should also contain Hindi and English to make it comprehensible. I am your host Urvashi Chauhan with your daily roundup of legal updates from across the country. Before we dive into the details, don't miss out an exciting new initiative by LiveLaw Academy, the Judicial Service Examinations Preparation Course. This comprehensive online course spanning 18 months is designed to help you ace your judiciary exams with classes by retired judges and expert faculty, easy to follow study materials, and all of this at a very affordable fee. If you are gearing up for the judiciary exams, this is a must-check opportunity. Limited scholarships are also available for those who qualify on a merit-cum-need basis. So act fast and enroll today. You can check all the details at www.livelawacademy.com. A senior advocate from Telangana has approached the Supreme Court regarding an FIR filed against him by his former client. The client has accused the advocate of taking 7 crores from him to allegedly bribe the High Court judges. According to the FIR filed against senior advocate Vedula Venkataramana in 2005, a member of scheduled caste community hired him as their lawyer for a land dispute case. They handed over important documents and paid him 30 lakh as legal fees. He assured them that the case was strong and the outcome would be favorable. Later, he allegedly demanded an additional 7 crore, claiming it was needed to bribe High Court judges for a favorable judgment. The complainants claimed that they paid this amount in installments. However, they later discovered that Venkataramana had secretly worked with the opposite party and received 25 crore from them. Despite multiple visits to his office, he neither refunded the full money nor properly handled the case. Also, when they demanded the 6 crore, which was still unpaid, Venkataramana allegedly used caste-based insults and even threatened their lives. Venkataramana filed a petition with the Telangana High Court asking for the FIR to be quashed. He argued that the allegations were vague, baseless, and related to a civil dispute and not a criminal one. He also claimed that there was no evidence to prove the payments made by the complainant. He said that no preliminary inquiry was done before filing the FIR as is required by law. But the Telangana High Court rejected his petition, stating that the allegations needed investigation and the FIR could not be dismissed. Now, the Supreme Court has also refused to quash the FIR. A bench of Justices Abhay S. Oak and Augustine George Massey issued notice in the SLP and said that the allegations leveled are grave. The allegation that money was obtained to bribe the judges casts a serious doubt on the independence of judiciary and implies that justice is up for sale. So the court said that such serious allegations need to be investigated. The Allahabad High Court has allowed the withdrawal of a PIL plea seeking an independent probe into the alleged incidents of police atrocities during the Sambhal Violence. This was because the government has already formed a Judicial Inquiry Commission to probe into the incident of violence. The plea was filed by Association for Protection of Civil Rights and the order was passed by a bench of Justices Ashwini Kumar Mishra and Justice Dr. Gautam Chaudhary. The court was also informed that all the prayers in the PIL petition fall within the scope of the Inquiry Commission formed by the government. The UP government constituted a 3-member judicial commission comprising retired Allahabad High Court Judge Devendra Kumar Arora, retired IAS officer Amit Mohan Prasad and retired IPS officer Arvind Kumar Jain last month to probe the violence that broke out in Sambhal district after a team led by an advocate commissioner surveyed the Mughal-era Jama Mosque on the orders of a local court. In the next update, the Supreme Court has directed Punjab state to explore the possibility of providing alternative accommodation to 39 families who are presently occupying flats in SAS Nagar Mohali Phase 11 for the past 40 years. These flats were meant for the 1984 Anti-Sikh Riots victims, and the families staying there do not have red cards given to identify the genuine victims of the riots. A special leave petition has been filed claiming that 39 families have been evicted by the authorities. It is their case that they were the residents of Jahangirpuri in Delhi and had to flee from there due to the riots. On the other hand, the authorities claim that the families are not genuine riot-affected victims but have trespassed into the premises and have been in unlawful occupation for 40 years. The authorities say that there are many other genuine families with economic difficulties who need shelter. In 2011, the authorities conducted an investigation and concluded that the petitioners were not genuine victims. Later, a family member filed a petition to cancel the eviction notices issued after this investigation. The bench of Justices J.B. Pardewala and R. Madhavan noted that this is a very peculiar problem, because on one hand, the petitioners have no legal right to continue occupying the premises, but they have been in possession for almost 40 years now. The court also found that families were put into possession at the time by some local MLAs. So, in order to strike a balance, the court directed the authorities to search for alternative accommodation for them. The court also inquired if it was possible for the authorities to provide accommodation to the economically weaker section families in another premises within Mohali. The Supreme Court has called for Union's response on Bihar Election Commission's plea against election of a Nepali citizen as Panchayat mukia. The respondent, who is the mukia, had become a Nepali citizen pursuant to a special drive in the year 2005-2006. In 2021, Panchayat elections were held in Bihar and he filed his nomination for the post of mukia for Bulaha Gram Panchayat. He won the election, but the rival candidate filed a complaint before the State Election Commission alleging that the respondent was a native of Nepal and thus ineligible to contest the election. The Election Commission held that the respondent was a Nepali citizen when the elections took place and held that he was ineligible to contest it under the Bihar Panchayati Raj Act of 2006. It was further held that the post of mukia would be treated as vacant and steps taken for fresh election. Challenging this, the respondent approached the Patna High Court. Initially, it dismissed the plea. The High Court observed that he had moved an application to get his name deleted from the Nepali citizenship register, but the same happened only in the year 2023 when he was already declared elected in the year 2021. But in appeal, a division bench of the High Court set aside the orders of Election Commission, directing it to refer the citizenship issue to the Union government. Till the issue was decided by the Union, the bench also said that the respondent could continue on the post of mukia. Now, the State Commission has appealed against this order before the top court. A bench of Justices Surya Kant and Ujjal Bhuyan of the Supreme Court passed the order for impleadment of Union of India because it is the competent authority to grant citizenship, and Election Commission, it said, was not empowered to decide the question. The Supreme Court today remarked on the ex-West Bengal Minister Partha Chatterjee that he was a corrupt person. The bench of Justices Surya Kant and Ujjal Bhuyan was hearing his bail petition in Cash for Jobs money laundering case. The scam, as you know, involves alleged illegal recruitment of assistant teachers under the West Bengal Board of Primary Education. Senior advocate Mukul Rohtagi, appearing for Chatterjee, said that no recovery had been made from him. Rohtagi also placed reliance on the recent judgments which granted bail in money laundering cases, citing the unlikelihood of early completion of trial. On the other hand, the Additional Solicitor General S.V. Raju for the Enforcement Directorate said that a supplementary charge sheet was filed last week and that charges could be framed in 4 months if Chatterjee cooperates. Justice Kant then said that the allegations are that the bribe money was taken from Class 4 employees and assistant primary teachers, and the proceeds of crime were diverted to dummy companies and proxy persons. He also remarked that though no recovery had been made from Chatterjee, it was unlikely that he would personally hold any money. He said that if bail was granted easily, it would be presumed that corrupt individuals can easily secure bail. The court has now reserved orders on bail. Stay tuned with us to know the decision. And now let me tell you, the Delhi High Court has held that collection of funds in an illegal way to commit a scheduled offence in future is not an offence of money laundering under PMLA. In this case, the Enforcement Directorate accused some members of banned organisation Popular Front of India of collecting money from unknown sources, falsifying donation receipts and using the money for planned illegal activities like terrorism. But the court noted that the money was collected before any illegal criminal act. Since no scheduled offence had yet occurred when the funds were collected, it could not be considered money laundering under the PMLA. Scheduled offences are serious crimes listed in the PMLA such as terrorism, corruption or drug trafficking, etc. For an act to qualify as money laundering under Section 3 of this Act, the proceeds like money or property must directly result from such a crime. The High Court said that offence committed by the collection of funds may be an offence under any law including a scheduled offence but cannot be termed as proceeds of crime to invoke Section 3. It further explained that the sequence matters for money laundering to apply. Thus, the scheduled offence must generate the money. Even if proceeds of crime were assumed to exist, the accused PFI members did not have control or dominion over those funds since they deposited them into accounts of the organisation. Justice Jasmeet Singh granted bail to the three accused here and said that special laws like PMLA should not lead to prolonged detention of individuals without trial, as this violates their fundamental right to life and liberty. The Rajasthan High Court, in a case related to Muslim marriages, has ruled that marriage certificates like the nikahnama should be clear, transparent and written in a language that is widely understood. It can be in English, Hindi, etc. instead of Urdu, which is not commonly known, especially by public servants or court officers. Justice Farjand Ali emphasized that using a commonly understood language would help avoid confusion in legal and administrative matters. The court also suggested that there should be a standardized format for the nikahnama printed in English or Hindi to simplify the process. Additionally, the court recommended that the district magistrate or collector of each district should maintain a registry of individuals authorized to perform nikah ceremonies. And only these registered individuals would be eligible to perform such ceremonies, ensuring accountability and preventing misuse. The court made these observations while hearing a case where the petitioners had relied on a nikahnama written in Urdu, but the court was unable to read it and comprehend it. This highlighted the practical challenges faced by government officials and institutions when dealing with such documents. The court has directed States Council to consult senior officials from Department of Minority Affairs on this issue and report back during the next hearing. The Secretary of Department of Home Affairs was also instructed to be present at the hearing. Stay tuned. For more information on the cases discussed here, you can visit our website at www.livelaw.in. Your support means the world to us. So please do not forget to like, share and subscribe to our channel. You can also support us by clicking the thanks button below our videos or by becoming a member for just 89 rupees per month.